the council, for the bar council of already from record filed last week. We are because I was yesterday observed that the investigation will not be yes, so my lords may give us just 15 minutes.
Whatever time is available, you request them. Yes. You are on which side? You adjust the time among them. If the time permits, because we will conclude it by tomorrow, 4 o'clock. Yes, Doctor.
My lords.
Your lordship has directed me to deposit some amount in your bail order.
Mentioning is before court number 2 today.
Today.
The order is by your lordship's registry.
You can't mention it before CB. Have some, maintain some decorum.
My lords, Article 233, 1 and 2.
Oh, Dr. Jit.
No, sir. And controversy arose with Satyanarayan Singh's judgment, my lords, where it said that there are two different streams of appointment, and they also found that my lords, it was an argument which was found acceptance that from
The notes given on the
judge.
You are appearing for whom?
I am appearing in 105.25. I am appearing for a person, my lords, a judicial officer.
Point?
At 501.25, Sudhanshu Upadhyay. My lords, he has completed 10 years, 8 years, 6 months before joining as a civil judge in 2015. And my lords, he appeared in 2018 in UP Higher Judicial Services, and his result is in sealed cover. Because he appeared in person to the orders. 501.25.
1.2.
yes.
He has completed more than 7 years. He has completed 8 years, 6 months as a lawyer before becoming a civil judge. He comes in that.
When did you become civil judge?
My lords?
When did you become civil judge?
My lord, 2015.
2015.
And he took examination, my lords. He sat for examination on 2018, my lords. His results is still in sealed cover, is what I am instructions. In UP Higher Judicial Services. And he is serving in UP as a civil judge.
Now what, your senior division or same?
Senior division. My lords, the entire.
Individual matters will not be deciding. We will be deciding only the questions.
Yes, my lord, then matter will be
report.
left to the
The
individual.
matters will go back to the.
Respective courts, my lord, for this. My lords, the genesis of the problem arose, my lords, as I began, my lords. Why stating that the locus of, my lords, a civil judge becoming a district judge would be under Article 233(1), and lawyer can become, my lords, advocate can become under 233(2). This separation is the basic fallacy, my lords.
That is done where is Satyanarayan.
Satyanarayan, it started with Satyanarayan, my lords, in specific terms, which is and my lords, Article 233 is, my lords, merely a declaration of appointment by the governor. My lords, Article 233(1) has a provisions, my lords may see, it is picked up from 1935 Act. My lords, just put it, my lords, how intelligently it has been, my lords, varied in our constitution, my lords. My lords, may see article, my lord, this is, my lords, Government of India Act, which many people say is the, my lords, a basic of our constitution, but my lords, it has been tweaked very intelligently. That's all I want. My lord, can you run to section, my lords, the Article 254 or section 254 of the Government of India Act 1935. District judge, etc. My lord says it. Appointments of persons to be and the post.
It is already there in the comparison.
Volume 4, page 136.
Where is there?
Okay, volume 4.
Mr. Bhushan has already referred to it in his opening argument.
My lord, what he wanted to say was, my lords, yes, that exercising his individual judgment has been taken off. Now, my lords, this is only the governor who will be bound by the, my lords, the consultation with the High Court. So there is no, my lord, it is basically a freedom from any state interference. My lords, Article 233, my lords, only points out that there will be no interference by the state government or any other body. It is only the governor and the High Court to ensure independence of the judiciary. It is not the source of my lords appointment. Even Chandramohan says so. My lords, because there are many, my lords have already, my lords, held one constitution bench of powers of the governor. Here, the governor, my lords, is in consultation with the High Court. My lords, unlike my lords appointments in the higher judicial, my lords, in the constitutional court of
Exercising his individual judgment has been taken out.
taken off. And now,
Therefore, now, when if that is taken out,
my lords,
then he will have to act on the aid and advice of the.
Correct. my lord, meaning thereby, Article 233 is not a source of appointment. It merely ensures independence of the judiciary. That a judiciary is completely out of the control of the state government. My lords, kindly see, my lords, in the entire chapter of subordinate courts, there is no interference by the state in any manner. Unlike, my lords, appointments of the High Court and Supreme Court, where they stated in consultation with the state. Here, the state is, my lords, relegated to, my lords, it is akin to Article 192(2) of the Constitution, my lords, wherein the power of the governor is, if a person disqualified after elections, it is only the Election Commission. Here, only the High Court. So, my lords, 233(a)(1), the basic fallacy arose because 233(1) has been taken as a source of appointment for judicial officers. It is not a source of appointment. It is merely a declaration that yes, the appointment of district judge will be only at the exercise of jurisdiction by the High Court and nobody else. My lord, kindly see that the entire scheme is, my lords, as far as the, my lords, persons below district judge is concerned, Public Service Commission is involved. My lords, below district judge appointments, Public Service Commission. District judge, only High Court. Only High Court. High Court and, my lords, Honorable Supreme Court and Honorable High Court, my lords, even consultation with the state. Therefore, my lords, the entire purpose of 233(1) was not as a source of appointment for promotion of a district judge. It was appointment of a district judge deholds any interference by the state. And this is stated in Chandramohan's case also, my lords. 5 judges, my lords. They said that 233(1) is a declaratory in form. It was reiterated in 1969 3 SCC. Well, this position of law that 233(1) is mere declaration of, my lords, appointment of a judge. Even lawyer, my lords, advocate would be appointed at 233(1) only. So they are not separate streams of appointment. With this entire, yes, my lords. My lords, therefore, my lords, our submission is that 1969 3 SCC also. Same proposition that 233(1) is mere declaration of appointment.
Is that 1963? Which is that?
1969 3 SCC 505.
There is a citation.
State of Assam.
State of Assam versus Kumeshwar Saikia.
Volume 5, page 199.
Volume
5.1.
5.1,
Page 196.
page 195.
But it is mere declaration of?
Appointment. It is not a source of appointment.
Then what is the source of appointment of a district judge?
Source of appointment would be 233(2), both for judicial officers, or 235, my lords, for subordinate below district judge. And my lords, this argument was raised in even Dheeraj More's case.
What argument?
That, my lords, Article 233(1) includes appointment of both the members of the bar as well as judiciary.
Yeah,
Yes,
exactly, yes, yes.
My lords, at page para 35 of Dheeraj More, it was raised. I'm sorry.
Come from.
Stick to the old case first.
My lords, I'm sorry.
Don't switch over to Dheeraj more immediately.
Well,
It becomes
You
difficult.
said that this was taken out of,
690 SCC, my lords.
So what we are relying in 1969 3 SC for what purpose?
My lord, to state that appointment of, my lord, district judges under 233(1) is not a source of appointment. everybody who is appointed district judge, whether he is a lawyer or a judge.
So show us that.
Which paragraph?
Yes, my lords. My lords, may I read held that by reason of definition given in 236, the word judicial service would mean.
That is by the,
My lords, para 6. Para 6.
Para 6.
My lords. Para 6.
Just read para 3. So backward. If they understand.
Yes, my lords. Para 3 was, my lords, that he was appointed by the governor. They said that the High Court, it is not appointment by the governor, by the High Court under Article 235, and therefore this is a void appointment. So to that the answer is, my lords, at para 6, it means that appointment as well as promotion of persons to be district judges is a matter of governor in consultation with the High Court, and the expression district judge includes an additional district judge and additional session judge. It must be remembered that district judge may be directly appointed or may be promoted from the subordinate ranks of the judiciary. The article is intended to take care of both. It concerns initial appointment and initial promotion of persons to either district judges or any of the categories included in it. Further, the promotion of district judge is a matter of control of the High Court. What is said of district judge really applies equally to additional district judge and additional session judge. Therefore, when the governor appointed Rajkova as an additional district judge, it could either be an appointment or a promotion in Article 223. If it was an appointment, it was a clearly matter under Article 233. If the
So it
notification,
doesn't distinguish between clause 1 or clause 2 of Article 233. It refers to the entire Article 233.
no, my lord, the argument,
Your contention that 233 1 is a declaration and 233 2 is a source.
correct.
But it does not take anywhere.
No, my lord.
Why, we don't know why are you arguing for that?
No, my lord, the argument was, this was argument also taken. The argument was that, my lords, that Article 233, my lords, appointment would embrace both advocates as well as the promotion.
Absolutely.
Article 220,
I
yes,
think we rephrase your argument. What you are saying is
my lords.
appointment and promotion come under Article 233(1),
My lord.
while Article 233(2) takes care of qualification only pertaining to the lawyer. We understand that, to that extent.
My
You
lord.
say appointment,
My lord.
which includes promotion, which gives the power to the governor in consultation with the High Court, come under 233, which means both categories, there is no classification there, both category will come under
Obliged.
this. And then so far as with respect to the qualification is concerned, it was made clear in subsection 2, we are not concerned with the one part, first part with this
My lords.
in-service candidates, and we are only taking into consideration of the law advocates and pleaders who want to have it over 7 years.
Correct, my lords. Our submission is, my lords, that kindly turn to Chandra Mohan.
Yes. Yes, from which page?
Chandra Mohan, my lords.
Yes. Yes,
My lord, SCR, internal page 89.
yes.
79 is what?
89.
179 of volume 1.
5.5. 1.1.
scheme of 180.
Page 182.
Well, paragraph starting from,
My lords, so far there is no dispute. Internal page 89, my lords, of the SCR. SCR, my lords, have it, my lord.
89.
89.
Yes,
It says so in categorical terms.
yes, over this one.
Page 192.
Yes,
So far there is no dispute. My lords, I'll just read.
We have read and reread it. How many times you want to read
No, my
it?
lords, all
If
that-
there are 15 councils, should the 15
No,
councils read it 15 times?
My lord, all that we are saying is, it says mere declaration. 233(1) is mere declaration is what wanted to know. my lords.
come to the middle.
Doubtless, if Article 233 stood alone, it may be argued that the governor may appoint any district judge, whether legally if not, he belongs to any service under state. But Article 231 is nothing more than a declaration of the general power of the governor in the matter of appointment of district judges. This is what I want to say.
Correct.
That is already said.
Meaning that,
Yesterday, so many times
my lord,
that
85
insofar as
SCC,
persons from service are concerned, there is no qualification. Insofar as lawyers, there are two streams. One, in-service candidates in the service of the state or the union, and secondly, from the lawyer. Insofar as first category is concerned, there is no qualification. Second category, the qualification is minimum 7 years of practice.
my My lord, my lord, how the difficulty arose because, my lords, in 1985, Satyanarayan said.
So you come to
Yes,
Satyanarayan then directly.
Yes, my lord, kindly read.
Why do you want to go to the cases which have been read at least
Yes,
half a
my lord,
dozen times?
Satyanarayan, kindly see, my lord, Satyanarayan. My lords, kindly turn to para 2 of the Satyanarayan.
Where is Satyanarayan? It's page number.
Space 395.
394.
395, volume 5.1, my lords.
So दूसरा volume होगा.
Volume 5.1, judgments volume, page 395.
Same volume.
Yeah.
My lords, I will commend the arguments which were made 4 decades back. These are the real submissions, my lords. These are our submission, my lords. Para 2, which was rejected in this judgment. Para 2, my.
One minute.
Yes.
The submission of Sri Lada and Sinha and Kir was that there is no constitutional inhibition against members of any subordinate judicial seeking to be appointed as district by direct recruitment, provided they had completed 7 practice at bar. The submission of learned counsel was that the members of the subordinate judiciary had put in 7 years of practice at the bar before joining the subordinate judicial service and who had gained experience as judicial officers by joining subordinate ought to be considered better fitted for appointment of district judges because of the additional experience gained by them rather than be penalized for that reason. The learned counsel submitted that the construction of Article 233 of the Constitution, which would render a member of subordinate judicial ineligible for appointment to the higher judicial because of the additional experience gained by him as a judicial, would be both unjust and paradoxical, unjust. It was also suggested that it would be extremely anomalous if a member of the Uttar Pradesh Judicial Services, who on the present construction of 230 is ineligible for appointment as a district judge by direct recruitment, is nevertheless eligible to be appointed as a judge of the Honorable High Court by reason of Article 2AA. Yesterday, my lords had pointed out this explanation. He would be eligible for becoming a High Court judge, but not for it, my lord, taking exams as district judge. On the other hand, my lord, this is how, my lord, the fallacy arose, my lord. Mr. Subramaniam, learned counsel respondent urged that there was a clear demarcation in the Constitution between two sources of recruitment, namely, those who were in service of the state or union to those who were not in such service. He contended the second clause of the Article 230 was attracted only to the second source. Now, this is, my lords, the problem begins. And in respect of candidates from that source, further qualification of 7 years as an advocate or pleader was made obligatory for eligibility. According to Mr. Subramaniam, a plain reading of both the clauses would show that while the second clause of Article 233 was applicable only to those who were already in service, the first clause was applicable to those already in service. He urged that any other constitution would lead to anomalous and absurd consequences. And such a member of
All the arguments not there.
So there,
Okay, please.
you skip everything, come
Yes.
to Article 333
Yes.
as follows.
Yes.
Therefore, my lord, this
These are all arguments.
my lord, I was pointing out both the argument. Now, my point is clear distinction, my lord. Put 229. My lord, the page, internal page, my lord. So this argument led to the, my lord, this bifurcation of 2 separate streams. And therefore, the entire problem arose. Therefore, I was reading both the submissions. In other words, as in the case of candidates, my lord, para 3, my lords, and the next page, 229. In other words, in case of candidates who are not members of a judicial, there must have been advocates or pleaders for not this, and they have to be recommended by the High Court before they become district judges. While in the case of candidates who are members of judicial service, the 7 rule has no application, but there has to be consultation with the High Court. A clear distinction is made between 2 sources of recruitment. Dichotomy is maintained. Now, my lords may turn to next page. Page 230.
Page?
230 of the same volume. Internal page. Page 401. 401 page, my lords. Chief Justice Subbarao then proceeded to consider whether the government could appoint a district judges person from services other than the judicial service. After pointing out that 233(1) was a declaration of general power of the governor in the matter of appointment decision, he did not lay down qualification of candidate to be appointed or denoted source from which the recruitment had to be made. He proceeded to state, but the source of recruitment is indicated in clause 2 of thereof. Under clause 2, sources are given, namely this and this. The source is 233(2), but my lords, kindly see reasoning which is at para 5. This created the entire problem.
That's because the council argued that this case, the case of the in-service candidate also should be brought under the 233(2). That was a problem.
Yes,
The council also did not understand. Unlike what all of you are arguing, now your argument is totally different here.
Yes.
Your argument is, 233(1) is a comprehensive provision. It takes care of everything.
yes, my lord.
233(2) operates on a separate field with restriction only to that.
Obvious.
Therefore, there is no question of fitting in a judge who's already serving into 233(2).
Correct.
That's all we say. That is the argument is different. Therefore,
Para 5, my lord, makes
considering it wrongly.
para 5 made all the difference, my lord.
It's all right.
And this was reiterated in Dheeraj Moore's case.
Yes, all right.
Dheeraj Moore's case. This
The main reasoning seems to be at 401, that otherwise they will steal a march over people.
Or all the others who are all senior to them.
but here it's open
That
competitive.
doesn't matter because
Doesn't matter.
There was question of 7 years,
Service.
question of recommendation High Court, all those things will not come. It's correct only. That in a way that's correct because now whatever you say that's irrelevant because the argument of your colleagues is only this. You just 233(1) does not exclude to mean there's a separate channel, and for direct recruitment it doesn't apply. It merely says about the qualification. For that they make it very clear. That's why they say you can't leave certain portion of the article and you have to read it in entirety. Every word has got a meaning. So you have to read it and then it's only speaks about whether if you're a lawyer, advocate or pleader, you require 7 years. That is not mentioned for the others. Yes.
And the point we want, it is not stealing marks. It is an open
yes.
open competitive exams. And my lords, Article 14
yes,
and
now,
my lords, I'll just last. My lords, the point we want to make is, my lords, that as far as my lords, this district judge examinations are concerned, they will come within the ambit of public employment. My lords, maybe the constitutional functionaries of High Court and Supreme Court may not be termed as public employment so far, my lords. But examinations till the district judge are part of the public employment as enshrined under Article 14 and 16 of the Constitution. Therefore, my lords, whenever you have a competitive exams, the law is that you should have the widest possible net so that you can talent the best possible talent available. So to exclude, my lord, that was the argument of Lal Sinhaji and Vinu Misra.
yes,
Problem is you are trying to repress it.
you are already,
See,
what step you are trying to
simply put what they are saying is there is no reservation.
Very well.
For the advocate, we'll put it that way.
That's all.
Yes, all thank you.
I'm sorry, my lord.
No, it's all right.
Oblige.
May it please, Millets. I appear in 501, the lead matter, and also 501.20 Millets, two judicial officers from two different states. Millets, one remarkable thing is that Millets, my lord's adherence to the timeline, I am grateful, and I will not exceed my time.
Yes.
Millets,
10 more minutes of mine.
Millets, though it's been argued extensively on the questions of law
Sorry,
and the
the
presidential.
which matter and which matter?
Millets, 501 minutes. I appear. And 501.20. Yes, I believe. Yes, Millets, 20.
Yes.
Millets, it's been extensively argued on all counts. My turn, it seems, is that, Millets. The facts have not been put in perspective in the lead case. It's a peculiar case.
So we are not going into the facts of the case.
So be it.
We have made it clear that we will be answering only the questions that are referred to us.
Right. Then, Millets, this case stands squarely covered by a judgment rendered by your lordships, the Honorable the Chief Justice of India, as his lordship then was, in Sunil Kumar Verma's case. Identical facts, but for one distinction. In that case, Millets, an officer, it's been there in the compilation, an advocate applies for the post. while the recruitment was on, he gets the post of Civil Judge Junior Division. Thereafterwards, Millets, he seeks the permission of the High Court and then appears for the district judge exam, both prelim and main. Eventually, when he's been selected, he sought the permission of the Honorable High Court to resign. And he resigned. Thereafterwards, he joined. Then, Millets, in course of time, Dheeraj More was decided. The Honorable High Court on its own issued a show cause notice and said that now Dheeraj More says that you could not be because you were in service then. Thereafterwards, he was removed. Then that's reached your lordships. Your lordships have held that at the time when he applied, he was not in service. Pending that one, he came into service. But by the time he joined the next post, that's district judge, additional district judge post, he resigned. All under the supervision of the High Court. Hence, it cannot be found fault with. My lords have had, Dheeraj More has no application to this one. In my case, Millets, only that distinction my lords could see. When I applied, I was a lawyer, not in the judicial post. Waiting for my turn to be selected, I got the post as a Civil Judge Junior.
You are protected, I think.
Beg-
You are protected by the.
I've still been in service, Millets.
Your facts are already told to us by Mr. Gupta yesterday.
Maybe, Millets. My-
You're continuing as a district judge now.
I'm still continuing, Millets, but it's been hanging. Certificate was issued in this case, Millets.
You are,
Kerala.
you are.
Indeed,
You are adequately safe. So,
Yes, Millets. That's the only endeavor, Millets. The distinction here is that, Millets, when I was the junior civil judge, I was discharged from service instead of resignation.
Argue only on the question.
Millets. Sunil Kumar Verma may take your lordships to that one, or else, Millets, it's been fresh in your lordship's memory, it may not be
Sunil
required.
Kumar Verma, you are not gone through. Yes.
So be it, Millets. Kindly come to Sunil Kumar Verma, Millets. Millets, in the compilation of their judgments, my lords could see 1075, volume 3. Sorry, 5.3 minutes.
How many compilations of judgments are there?
There is 7 compilations.
Judgments?
I was told, Millets.
This will be TDS 299, 5.3.
The running number is 1077, where my lords have set out the facts and then rendered the judgment. This is said to be 5.3.
What is the citation? This.
Millets, citation. This is 2022 9 SEC 686.
6.
86. Para 2 sets out the fact, Millets. At page 1077. Para 2 Millets.
Yes.
Last 3 lines. Calling upon the appellant to show cause the High Court of Judicature at Patna, thereby calling upon.
Read from the first line.
Beg your lordship's pardon?
Read from the first line of the paragraph.
By the said writ
Now you
petition.
also adopted yourself to the Supreme Court practice
Yes, Millets.
of selective reading.
I will read, Millets. By the said writ petition, the appellant had challenged letter number so-and-so, dated 18/5/2020, and letter number so-and-so, dated so-and-so, issued by the High Court of Judicature at Patna, thereby calling upon the appellant to show cause as to why his services from the post of additional district and session judge should not be terminated in view of the judgment of this court in Dheeraj More versus High Court of Delhi. By way of an amendment to the petition, the appellant has also challenged letter number so-and-so, by which his services in effect were terminated. Then para 4 Millets, the facts and brief lacing to the leading to the present appeal or agenda. The High Court of Judicature at Patna had invited applications for recruitment to the post of additional district and session judge. The appellant at the relevant point of time was an advocate having completed practice of more than 7 years. As such, he was eligible to apply for the said post. Accordingly, he had applied prior to 16/9/2016, which was the last date for submitting the application. Para 6, my lords, may kindly see. In the meantime, the state of Uttar Pradesh had invited applications for the post of civil judge junior division. The appellant has also applied for the said post. After being successful in the selection process, he was appointed on 16/1/2017 as a civil judge junior division. Para 7 minutes. After the appellant's appointment in the subordinate judicial service in the state of Uttar Pradesh, the selection process for recruitment in the Bihar Superior Judicial Services proceeded further. After obtaining the requisite permission from the High Court of Judicature at Allahabad, the appellant participated in the selection process conducted by the High Court of Judicature at Patna for the post of additional district and session judge. The said selection process consisted of etc. Per 8 minutes. With a notification dated 7/8/2018, the appellant was offered appointment. The appellant therefore obtained permission from the High Court of Judicature at Allahabad for resigning from the Uttar Pradesh Judicial Service so as to join his service as additional district judge in the state of Bihar. 9 minutes. Consequently, the appellant joined the Bihar Superior Judicial Service with effect from 21/8/2018. In the meantime, the judgment of this court in Dirajmore was delivered on 19/2/2020. Kindly come to para 10 minutes. On the basis of the said judgment, the High Court of Judicature of Patna issued a show cause notice as referred to here and above. After considering the reply, the High Court of Patna recommended the cancellation of the appellant's candidature. Para 12 minutes. That's the argument. I need not trouble your lordships. Then kindly come to para 15. The present appeal arises out of peculiar facts and circumstances. Then my lords have said, undisputedly, the appellant had applied in response to the advertisement issued by the High Court of Judicature at Patna. As on the date of his application, he was a lawyer, having practiced for more than 7 years, and was therefore very much eligible to apply for the direct recruitment category. Kindly come to page para 18 minutes. 17 should I have it? Minutes. Para 17. In the meantime, the selection process conducted by the High Court of Judicature at Patna, which had come to a standstill, proceeded further in the year 2018. The appellant, therefore, after obtaining the requisite permission from the High Court of Judicature at Allahabad, participated in this selection process, in which he was found to be meritorious. After being selected, he applied to the High Court of Judicature at Allahabad for grant of permission to resign so as to join the state of Bihar as an additional district and session judge. It could thus be seen that, firstly, the appellant was neither in service of the Bihar subordinate judicial service on the date on which he applied, and secondly, nor was he in the service of the Bihar subordinate judicial officers cadre on the date on which he was selected. My lords may kindly come to minutes para 20. That's the crux of it. It is further to be noted that the appellant was vigilant enough to seek permission of the High Court of Judicature at Allahabad before participating in the selection process. Not only that, after he was found meritorious, he again sought permission of the High Court of Judicature at Allahabad to resign from the said services so as to join the Bihar Superior Judicial Services. My humble submission, the only distinction is Millets.
Not correctly decided.
Beg your lordship.
This is not correctly decided.
Millets.
This is a judgment by 2 judges.
Millets.
It was bound by Dheeraj More. Dheeraj More is of 3 judges.
Millets.
Either Dheeraj More was not.
My learned friends have argued extensively. If I am allowed, I'll argue on Dheeraj More's soundness.
But Dheeraj More clearly says that he has to remain an advocate till the time is appointed.
Millets, that's not to be found anywhere in the Constitution, Article
That is what
233.
Dheeraj More says.
And my lords could not read a sentence.
But 2 judges were bound by Dheeraj More.
Millets, in that view of the matter, we find that the law laid down in Dheeraj More is not applicable in the peculiar facts and circumstances of the present case. So that's how my lords have distinguished. Millets, there are many devices to say and not to say on the face of it that it could not be the correct law.
Who knows better than you?
Millets, since my lords have said Millets, I have got time, a couple of minutes, Millets, because
It can't be said to be Parimkira because Dheeraj More has been referred to. But Dheeraj More has not been correctly.
it's been
applied.
referred to Millets. And my lords have held that on factual aspect, it's completely different. So that's why millets, even strength of higher cadre, rather judgment millets, would not dilute once it's been referred to. Millets, here, the only distinction my lordship may kindly appreciate. He was in one state as an
We are
officer.
not going down the facts, we are only deciding the questions of.
So be it, millets. Millets, now millets, my lordship may kindly appreciate.
Saying from yesterday that if we decide question number 4 in the affirmative,
Yes, millets.
everything would stand over.
Millets. This case apart, millets, I may plead on behalf of thousands of young, brilliant
Don't give,
lawyers.
don't give a speech here.
No, millets, I'm not giving. I'm only submitting the fact. Millets may kindly appreciate the profile has changed.
From the Bar Council of, the
Millets, the interpretation, my humble submission is, must be purposive. My lords may kindly appreciate, for whatever reason, maybe financial compulsion or love of profession, being a judge, my lords have seen somebody could make tons of money as an advocate, still they volunteer to be judges, be it of whatever grade, even High Court and this Honorable Supreme Court, still.
and some of them resign from the services.
To make money. And then make tons of money.
Millets, that shows that just because somebody has been in service cannot be a discounting factor for him to be selected at the higher level. His services are needed. My lords could see gold medalists, Ivy League graduates and postgraduates. They have joined as junior civil judges. And they cannot be millets. And one more submission, millets, that I gathered that it should have been 7 years continuous service. Millets, with great respect, the interpretation when it comes to 233(2) millets, it doesn't speak of continuity. I may just give one example to that effect, millets. Somebody may practice as a lawyer in a high court for 5 years. Then he gets a job in a bank and he leaves. 5 years, 6 years, he works in there. And he comes back. Then again, he works for 9 years, rather practices 9 years as a lawyer in a high court. Then put together, he has completed 10 years as was required, 217. Then, millets, in that context, can we say that he is not qualified to be a judge? And perhaps they prove to be one of the best judges? And continuity, millets, may not be read into because it becomes quite narrow.
Disconnect to the profession, sir.
Millets, disconnect to the profession.
By an individual.
Millets, may I submit, millets?
So Naidu,
Yes, millets.
by an individual example,
Yes, millets.
you cannot lay down the general principles.
There are others also, millets, with the same example. Millets, disconnect. My friend pointed out, millets, Krishna Iyer was a minister. And millets, Chief Justice John Marshall, the greatest Chief Justice, did not complete his law. And American Constitution has never provided for qualification as law degree is not a qualification there. A doctor has become a judge, Supreme Court judge.
Cannot be taken into consideration.
I'm saying, millets, continuity may not be. It's only the passion. And at the end, the qualification. Because for various circumstances, they may be compelled to have different options. Once they come back and they continue, this restriction, millets, given our economic conditions.
Wait for 7 years.
That's all, millets, my submission. If it were to be a speech. Millets, I appear in 501.20 also, millets.
Very well, we not.
Since my lords are not inclined to have the facts, millets,
After we decide the question, the matters will go back to the.
so be it. I'm grateful for the opportunity, millets. Great.
Whatever, if the review is allowed,
No, 501 is substantial. It's an appeal.
we are answering the question. Once the questions are answered, then the review petitions will go back to the benches and they will be decided in accordance with
So be it, millets. Grateful.
whatever has been held by, whatever
Great.
will be held by the.
Grateful for the opportunity, millets.
Like the reviews can be allowed, because once your lordship comes to the conclusion that Dheeraj Moore was wrong, then the reviews will be allowed. In fact, your lordship had already came to the conclusion that it was already referred to a constitution bench, wrongly heard by 3.
After answering the question, pose the individual matters.
One of the questions which.
They would hardly take half a day sitting all those 20, 30 matters.
Just, Lord, that rule would also have to be quashed, which, Lord, does not permit civil judges to be there. Don't leave that for the regular bench. That must be decided by the Constitution.
Millets, in the cases I appear, all 3 judicial officers are still continuing.
All 3 of them, you are lucky.
Great.
In Dheeraj Moore also continues.
He doesn't continue. He will not continue.
Rajneesh can.
Not as a, not as a district. Selection was kept in a way.
Rajneesh is continuing, the Viceroy one, he is continuing.
They will be considered.
Neeraj was not allowed to participate.
Not allowed to.
At the inter,
Yes.
Your Lordship may recollect, he was appearing in court. He was before your Lordship every day. Till your Lordship said that. No. It's not proper for you to.
no, he was not. He was not.
So that was somebody from the Delhi district. Judiciary. When I was sitting with Justice Nageshwar Rao
Those were two brothers who used to come from Delhi.
from Delhi.
Yes,
Justice,
I was appearing for them. When your lordship said, you should go to court, what are you doing standing?
Court 5.
Yes, court five. I was appearing. Yes.
Yes, Mr. Gunat, you are appearing for whom?
I'm appearing Viceroy one for them, since Naidu has covered the point, I have, because I have nothing more, your Lordship said.
Alright.
It is being said to the
No, you are appearing for?
Viceroy one, because.
Same, there is more.
Same. So that it is nothing, there is nothing more to argue in this matter. Rajneesh. Yeah. We were arguing, we are appearing together in the matter.
Okay.
Okay.
Thank you. You are recorded your.
Please,
Yes, Mr.
Manoj, I appear in 50.1.11, possibly one of the most unfortunate cases. I practiced for more than 11 years. I topped the civil judge's exam, appointed as a civil judge, practiced as a
Sorry?
civil judge.
You are in?
501.11, yeah. Give copies, other side of. Just one page. Just,
For a change, you are not
my
my
prop-
intervener.
no, not the interview, for a change, yes. Yeah, I just give it to him also. I've just put my relevant facts. I'm not going into the facts. I'm just saying what happened. So after topping it, he participated in the district judge's exam after in his 32 petition, your lordships permitted him to participate. And he topped that as well, the exam. He's appointed as a district judge in 2018. After in 2010, he had participated, he had topped the exam cancelled. 2018 participates, tops, he's a district judge. Then the matter is here. While he's a district judge, the Dirajmore judgment comes. Next day, they repatriate him. Next day, 19th, Dirajmore, 20th, repatriated. So as of now, he has been repatriated. It's a moment of great anguish. He's had a heart attack, 3 stents, etc. It's a shocking thing for to happen to a person. But anyway, now on the law, my lords. Your lordships have gone through judgments. 2 things I want to say on judgments your lordships have already seen. On Rameshwar Dayal, specific question number 2 framed with reference to has been, that is specifically answered. Facts are relevant, but your lordships have gone through it. Just look at those 2 respondents again. Interesting, actually, a large part of this judgment deals with the 2 portraits which are in our neighboring courtroom. Justice H.R. Khanna is one of the 5
Yes.
people mentioned in
But
Rameshwar Dayal.
He was not from the services.
I'm sorry, Manoj?
The question with
He was
whether
He was not. He was the other 3.
His practice at Lahore could be taken into
Correct.
consideration.
To be taken. I agree. So he was not, he's on the other 3. We are only considering those 2 for the purposes of our facts.
Swani and.
Correct. The other one is even more interesting. Justice Iyer's portrait, which has gone for refurbishing. Justice Iyer was a judge of the Madras High Court. In those days, retirement was 60. So he passed 60, he had retired. It was after he was retired that he was brought to the Supreme Court as a judge. That's actually happened many times after that, including Justice Fatima Bibi, many others, Justice Baharul Islam, the other Justice Iyer, all of them. In fact, the other Justice Iyer stayed on till the age, he must have been the longest serving in this court, age of 68. He was as an ad hoc judge twice appointed thereafter, after being a judge. So the fact that you have an interval where you don't continue being a judge, but you're reckoned and appointed, it's happened here. 5 times it's happened in the Supreme Court itself. Now, just coming back. So Rameshwar Dayal, that. Second, on what the other Dr. Singhvi showed your lordships this morning, with reference to the state of Assam case, that one sentence in the middle is very, very important. In the middle of para 6, they were talking about the individual concern. The individual concerned in that case, specifically, open that para 6 and show. The individual in that case, specifically, that's the state of Assam case.
Chandramohan.
Yes, if I can, Raj Kova is his name. He was the district registrar. That's a constitution bench.
You're Satyanarayan.
No, this is State of Assam versus Kusheshwar Saikia. This morning, Mr. Singhvi, Manish Singhvi showed your lordships. One judgment, 7 paragraphs long.
1969.
69, that's the one. That's the one. In that, that was a person who was a Munsif, my lord, who was acting as a registrar in the Assam in Guwahati High Court. So that gentleman, as far as he was concerned, it was a question which arose regarding his promotion. But if you see the middle of page 200, para 6, it's in volume 5.1, para 6. Just I want you to just see the middle.
Yes.
And it's important because this paragraph, the first 7 lines are extracted in Dheeraj More. And then it suddenly amputates itself and stops and doesn't go on to the next 2 sentences, which would have made a huge difference. The middle of the paragraph, can I read? Therefore, when the governor,
Yes.
about 5 lines down.
Appointed Raj Kova.
Yes, when the governor appointed Raj Kova an additional district judge, it could either be an appointment or a promotion under Article 233. This is important because Raj Kova was actually a judge. He was a civil judge, a munsif who was acting as the registrar. On the facts, the Constitution bench notes that Raj Kova is eligible both streams. This is why this sentence is important, because the Constitution bench is grimly aware even then that you can come in even if you are a judge. You can come in as an advocate. This sentence is important for that purpose. So I'm just redrawing as far as the facts are concerned that the court is aware that Raj Kova, being a judge, could have come in as an advocate. Therefore, it goes to 233(2). I will, don't worry, I will. If it was an appointment, it was clearly a matter under 233. If the notification be treated as promotion of Raj Kova from the junior service to the senior service, it was a promotion of a person to be a district judge, which expression as shown above includes an additional district judge. In our opinion, it was the latter. Thus, there is no doubt that the appointment of Raj Kova as additional district judge by the governor was a promotion and was made under Article 233. It could not be made under 235, etc. Unless Mr. Singh wants me to read something else which he feels frighteningly relevant here. Was it error?
There the High Court found that
Correct.
he could be promoted only under 235
Correct.
and not under 233.
Correct.
And
Correct.
The Supreme Court reversed that,
Yes.
holding that the power to appoint and promote
Both fall
also
under 233.
flow in 233.
I'm grateful. I'm grateful. But while saying so, shorn of the irrelevant sentences my friend wants me to read, the relevant sentence in my view is the middle one. Now, if you, lordships, just note.
Which have been amputed according to you in the Dheeraj More?
In Dheeraj More, para 35 extracts, and if you keep these side by side, this is at page 138, right? That's the other one, SCC volume, no? Mr. Patwalia.
That is a Patwalia's
Mr. Patwalia's volume, page 138. So all 3 constitution benches which have some bearing on this, all 3 are ad idem in our favor.
Take a compilation. SCT one. Right. Para 45.
35 at page 138 of this, 138. The truly well-prepared court masters have all the post-its kept on the side of their stool so they can flag it immediately. If I can just read that, para 35, it was submitted that ultimately the appointment of the bar member is also made under 233(1). In State of Assam versus Kusheshwar Saikia, this court observed, and it extracts para 5, para 6, and then it suddenly stops where it concerns initial appointment and initial promotion of persons to be either district judges or any of the categories included in it. And then says the decision is of no avail as the question in the present case is different. Though the appointment is made under 233(1), but the source and the channel for judicial officers of the promotion and for the members of the bar is by direct recruitment.
This is contrary to what,
Exactly.
because
If
research holds that sources are common
common,
for both
exactly.
promotion as well as.
Exactly. So if they had, and this is why facts sometimes bear relevance when you're going through judgments, especially for a constitution bench. Your lordships are laying this down, it will be cited forever. It's necessary for us seeing the background in which each of.
Till it is overruled by 7.
No, I'm hoping that won't happen, Malats, because again, everybody involved will be imperiled once again. So now I'm done with that.
The one thing is, there
yes.
are 6, would have been a little bit more clearer.
It could have been, but I don't think they, yes,
233 only deals with appointment.
correct.
Whether a promotion or a direct recruitment, it's a modes of appointment.
Yes, it is.
Both are dealing with appointment. That's what they actually meant.
Correct. That's what they meant.
You can call a promotion, in which case lawyers will, advocates will not have a role.
Correct.
The other is they direct appointment. But no, by way of promotion, you will be appointed.
That's
Because it is service itself, no. That's why the difference between, you see, 233 and 234.
correct.
234 speaks about recruitment.
Yes,
233 speaks about appointment.
appointment. That's true. That's true.
Yes.
No, that
The argument of the state
yes,
as well as the respondent was that it was a promotion under 235.
yes.
That has been rejected by the constitution. bench.
Squarely saying that it comes under 233. So that answers the question. Now, because your lordships are going on strict timelines without rejoinders, I want to raise what I think are 2 arguments which they have made in their written submissions and how we would meet them. So if your lordship will just bear with me for a minute on that. These are their arguments. First is dealing with the other 2 provisions dealing with Supreme Court appointments and High Court appointments, 124 and 217. If your lordship will just take the Constitution with me for a minute. Article 124, my lords.
Those volumes.
The Constitution.
Naran edition. They should.
Article 124.
124.
There are explanations which have been inserted in both 124 from the inception and Article 217. Now, their argument in a nutshell is that, look, there is no such explanation in 233. Therefore, as when you reckon the period, you can't reckon the period that they were advocates. So please just see 124 first. 124, explanation 2. 124, as your lordships are familiar with, the candidate must have been 5 years a judge of a high court or of 2 or more courts in succession, has been 10 years an advocate, and of a high court or of 2 or more such courts in succession, or C, is in the opinion of the president a distinguished jurist. Unfortunately, us poor advocates of the Supreme Court are not included in this because we have to be advocates of a high court or 2 or more high courts. But anyway, explanation 2, my lords. In computing for the purpose of this clause, so this has a specific inclusion with reference to the period that will be reckoned. Now, this is dealing with where you are an advocate, your period as a judicial officer will be considered, not the other way around. We are arguing the other way around, that I'm a judicial officer, please reckon my period as an advocate. This is not an explanation that deals with that. This is an explanation that deals with the opposite. Now please come to Article 217. In 217, Clause 2, again, 10 years held judicial office or 10 years advocate. The explanations, there are 2 explanations relevant to us. First is A, this is under 217(2)(a).
Explanation?
Explanation A and AA, A and AA. AA was inserted, my lords, after the tribunal's provisions came into the Constitution's 44th Amendment for the purpose of ensuring, including the service in the tribunal. AA came to be inserted. A was there from the outset. So if I can just show A and AA. In computing the period during which a person has held judicial office in the territory of India, there shall be included any period. Please note the words after, because that's fallen for interpretation by a 3-judge bench here. After and he has held. After and has held have both fallen for interpretation. Any judicial office during which the person has been an advocate of a high court or has held the office of a member of a tribunal or any post under the union or state requiring special knowledge of law. Now this is A. B, AA. In computing the period during which a person has been an advocate of a high court, there shall be included any period during which the person has held judicial office or the office of member of a tribunal or post under the union or state requiring special knowledge of law. Now this AA is similar to the explanation under 124. If you want to calculate the period when he has been an advocate, you will include the period as a judge. As I said, ours is dealing with the converse case. Now that converse case may have been in some way covered by A, because A says, in computing the period during which a person has held judicial office, there shall be included any period has held judicial office during which the person has been an advocate of a high court. The reason this provision fell for interpretation is that it came up in the case of Purnima, my lords, which your lordships will find. I'm just giving you the citation is 2023 12 SEC 519. It is at page 1080. I'm not reading the judgment at all of volume 5.3. 1080 of 5.3. It's a 3-judge decision.
Page number
1080, authored by Chief Justice Bobde. Now, that judgment is dealing with a situation where it's not after, but it's before. So, this explanation says that for computing the period the person has held judicial office, they include any period after judicial office during which the period has been an advocate of a high court. This provision was interpreted because people who had been advocates prior to them being judge of any sort said that, look, that period should be included in reckoning. The court said, you want us to read after as before. Constitution doesn't permit it on a plain reading because an explanation exists. That explanation came in expressly to exclude the prior period. That you can't, when reckoning judicial office for the purposes of 217, include within that a period when you were an advocate prior. I hope I'm making myself clear. It's only that after a judge you have been an advocate, you can calculate that. The absence of such an explanation in 233 endures in our favor, not in their favor, because there's no before after now, which controls 233. So the period when we were an advocate obviously must be added to the period that I was a judge. In my particular specific case, it doesn't matter because I have 7+ in both situations. But I'm saying generally on the proposition of law, that earlier period has to be added to the judicial period because the explanation is absent. And the other two explanations in 124 and in AA of 217 have no bearing because it's calculating for the purpose. I'm sorry.
Explanations are absent. There is a question of now 233(2) specifically refers about the qualification.
Correct.
Which is required for
Which is
if it is absent, there is a question of inferring something.
Exactly.
And then
I'm grateful. I'm just saying this is because this is an argument they've taken. The second argument which I could perceive is this. Rule 14.
Talking about eligibility, we can't just in the absence of anything.
Absolutely.
You can say
yes.
There have been judicial officers. Now 233(2) says with the recommendation of the High Court insofar lawyer is concerned.
Yes.
They are already under the control of the High Court there.
Yes.
235 is there and other provisions are there. Therefore, it is presumed that the High Court has got ample jurisdiction consulted with frame the rules or regulation with respect to their eligibility.
I'm grateful.
To that extent, we can appreciate it.
I'm grateful.
Yes.
The second, if you just pick up my note.
Yes.
The other argument, I'm sorry, I'll just wrap this up in 2 minutes. The other argument is that there is a rule 14
Yes.
I'm anticipating that they will argue this. It's not expressly there in their written submissions, but it should be because it goes to the facts of the case. In Chandra Mohan Malad, there were a bunch of rules that were challenged in the Chandra Mohan Constitution bench. Those rules were not expressly struck down, but they were read down. If they were to make the argument that Rule 14,
The rule which permitted an executive magistrate
correct,
was struck down.
yes,
It was held to be quality of the doctrine of separation of powers.
correct. One of the arguments they could take, I don't want to be supplying it, but because we won't have a rejoinder, I want to just say,
Take, we know what you are saying. Yes.
yes,
Only they'll raise it.
yes. So that Rule 14, which is extracted in Chandra Mohan, if the striking down of that rule has the consequence of shutting the door on us, I don't believe it does, but it's possible that they will take that argument after reading the rule and trying to read it in a way that it will shut the door to us. I want to say that that will have absolutely no bearing in view of the subsequent clarifications that have come in judgments. Chandra Mohan 2 also exists, but it's not germane for the purpose of this, it's just for understanding Chandra Mohan 2. If you see this note now, Roman 2 in my note, is again on the held and has been point that it has been construed by two judgments in the context of 217. I've given the page number at, give me the page numbers of, where's that? Yeah, why you give me an old note?
929
Yes,
at 946.
correct,
947.
correct. So please just see that. The at pages at where is, do you have? 946, whatever the printout says. 946, 947, and at page 635, these two deal with it. I've given the 6, I think, very serious errors which are there in Dheeraj More.
Yes. All right.
And in any event, in my view, my lords, in public interest, when you're looking at it, it has to be a larger pool of judges. We have the statistics as far as this particular state, which is Telangana, is concerned, where the numbers show us that after Dheeraj More, we have vacancies, we don't have people to fill them.
No, yesterday also we said that we will not go to that.
I'm grateful for a patient here.
Before my learned friend starts, there's an interesting story regarding Rajkua, who was appointment, my lord. Upendran Rajkua, he was a district judge. He was convicted for murdering his wife and 3 daughters and sentenced, my lord.
Sentenced to, but then that was set aside.
And sentenced to death, my lord. And he was,
Yeah, but then that was set aside by the High Court.
no, that was upheld by your lordship. He was executed by this court. He was sentenced to death by the district judge, affirmed by the High Court and this court. Finally, he was executed for murdering his wife and 3 daughters. And buried in the official residence of the district judge, Dhubri.
May I be excused?
Yes.
Yes.
Well, I'm appearing in the very matter in which my learned friend, a few minutes, my lord, that I will not repeat
Don't
whatever.
commit 2 lawyers for one matter. That's a.
Okay, please go into the fact. Don't go to the facts. They already said.
No, I am not going into facts. Only one sentence in the Chandra Mohan's case, I will draw your lordship's attention to that, my lord. That is at page 192 in para 16. Their lordships are categorically held that for 233 2 appointment, 2 sources are there. One is from service and the other is for advocate. That was not disturbed at any point of time. Categorically held, my lord. So once these in-service candidates are held eligible to be considered for 233 2, there is no question of excluding judicial office. Now, my lord, wherever the Constitution wanted to either disqualify or exclude any particular category, it was very specific, my lord. I'll only draw your lordship's attention to few articles. For example, Article 58, the deal 58. Well, very quickly, my lord, I'll refer to the articles and I will not take much of your lordship. Only by way of illustration. Dealing with the President of India, my lord. No person shall be eligible for election to the president as he is unless he is a citizen of India, has completed age of, so many things are there. So the provision was very clear in clear terms that exclusion. Wherever the exclusion, the parliament or the constitution wanted to exclude a particular category, the provision was very specific in negative terms. Similarly,
on the contrary, this provides for qualification.
No, I'm only trying
qualification.
Referring to 58 to exclusion.
58 to me.
No person, no person. Very good.
Shall not be,
Said no person.
both, in both ways, my lord. The qualify, in both ways, 58(1) as well as 2, they are couched in negative terms. Similarly, 157 for governor, 63, I am only referring to save your lordship time. Article 66(3) for the vice president. Article 84, my lord, for members of parliament. That is still categorical, and Article 84.
Article
84, my lord.
84 is for member of parliament.
Member of parliament. 84. A person shall not be qualified to be chosen to fill the seat of parliament unless he is a citizen of India, so on and so forth. In addition to that, my lord, 102, Article 102, how they process disqualification. If a group of persons are there, and if a particular group is to be disqualified, there also the constitution is very specific. The persons may appear to be falling in the same group, but if a particular group is to be disqualified, the provision was very clear. 102, my lord. Similarly, in the case of course, 217 and 124, your lordships are aware, the appointment of judges, it is couched in negative terms, sir.
Please appreciate there's a difference between qualification and eligibility.
Yes, madam.
There is indeed a
Yes.
difference, there are subtle differences.
Now, I am only coming to this
Talking
233.
about qualification, we are not talking about qualification.
No, now coming to 233, it does not say that a particular category.
We appreciate that, but what we are trying to tell you is that speaking about qualification is about eligibility.
Yes, ma'am. It does not disqualify any. Whole difficulty is, my lord, if that word only is shifted to displace that after if the whole controversy will stand. That was done in the case of, by translation. And translation by the provisions of Constitution itself, my lord, Article 394. Article 394 makes it clear that the Hindi translation will be authentic even in the event of there being any doubt or clarity. Here, the Hindi translation category is only such person, if he is not in state or central service or judicial service, he shall be eligible if only he has got 7 years of standing at bar. That doesn't mean that the person in the service is disqualified. Had that been the intention, the words would have been very clear that these persons will not be eligible to be qualified. And it is not uncommon, my lord, UPSC, if a person is already in IPS, he can compete for IAS, examination is same, and wherever they want. For example, in LIC, my lord, if they want to appoint the post of, fill the post of attender, they will exclude the persons who have studied more and above metric. So the appointing authority or the constitution or rule making authority will be clear wherever they want to exclude or disqualify. Both the things, either exclusion or disqualification. None of them is present in Article 233.
Your argument should be, it speaks about eligibility.
Yes, madam.
Qualification is different.
Yes, madam.
For example,
Yes.
somebody is of
Yes.
insane mind.
Yes.
Somebody
No.
is
Yes.
solvent. To be disqualified.
Yes, madam.
Eligibility means.
Yeah, eligibility.
Listen.
Yes, eligibility, madam.
Why don't you allow us to say? You are otherwise qualified. We are only trying to tell you in your favor only.
Yes, madam.
You read subsection 2.
Yes, madam.
It does not disqualify
Yes.
the service candidate.
In service.
But it gives an eligibility to the lawyer, which means
Yes.
lawyers themselves is not disqualified,
Yes.
but whoever will be eligible within that group.
Yes, madam.
Therefore, what you have to say, disqualification is not there.
Yes, madam.
It speaks about only eligibility.
Eligibility.
That is the reason why
Yes, madam.
it does not deal with the other thing, and then it clarifies that eligibility is only required for only B category of persons, not A.
Yes.
To that extent, we agree with you.
Yes. And that part of it was very clearly mentioned in Chandram Kumar's constitutional bench of the Honorable Court in para 16 category.
Okay.
I am much obliged to your lordship for providing this. 7 years. Yeah. 7 years, it can be in terms of the service or the, as my lieutenant has just, they are virtually interchangeable in the sense, slight change as to the timing, the practice at the bar as well as service in judiciary. Ultimately, the aim is to ensure the best qualified candidates are there selected for this purpose. And
That is already done.
yes,
Thank you.
much obliged. Much obliged.
May it please, my lords. My lords, my submissions are filed in volume 1, written submissions for the petitioners. I've just prepared a very brief 2-pager also. I'll hand that over. Just that summarize these submissions. They're not very long. They're about 12 pages. But I'll start with this, my lord. It will be PDF page 40.
Yes.
PDF page 40.
Yes.
Yes. Now, my lords, I am in item 501.9. I represent Mr. Manglesh Chaube, a serving judge, my lords, enrolled at the bar in 2008, joins as Civil Judge Junior Division 2011. Promoted, my lords, to the cadre of Civil Judge Senior in 2016. What is important, my lords, is Mr. Chaube files a petition before the Supreme Court to appear in direct recruitment examinations for Delhi, Gujarat, etc., my lords. Dheeraj Moore at that point is referred to a larger bench in 2018. Mr. Chaube is granted permission by the Supreme Court to appear for direct recruitment of district judges in Haryana. In 2019, he appears in the direct recruitment exam. The question paper for this exam, he says, is the same as LDCE. He secures second rank, called for viva voce by the Punjab and Haryana High Court. Dheeraj Moore comes out as a judgment, 2027 SCC 401. Mr. Chaube, the petitioner, is disallowed from appearing in the viva for the direct recruitment exam. So, my lords, this is the client that I represent, but with great humility, I also say this, that when I was looking at the figures and statistics on the Ministry of Justice's website, it says this, that there are 25,870 sanctioned posts for the subordinate judiciary in India. Civil Judge Junior 1,000, Civil Judge Senior 6,000, District Judges 8,000 roughly, total strength 25,870. There are 4,789 vacancies. So in many ways, what is before my lords is the stories, the cases, the journeys, the lives, the adjudication of these 25,000 sanctioned posts. So, may it please, my lords. My lords, in 90, Constitution is adopted, and from 46 to 49, during partition, when the Constitution is being written, the framers of our Constitution commit to something very special and specific, which has bearing on, as my Lord Justice Sundaresh said, basic structure also. The Constitution framers committed to an integrated judiciary. What was this integrated judiciary meant to be? My lords, I'll just take you only to 2 documents over the next 15 minutes. One is the Constituent Assembly Debates, volume 4.1, page 942. This was the framers' vision for an integrated judiciary. If I may just take you there, my lords. This is volume 4.1, page 942. Constituent Assembly Debates, volume 7, page 26, 4th November 1948. At that time, this was a very important day, my lords, because this was the first time the framers were sitting in the Constituent Assembly again after the death of Bapu. And a few days before this, Muhammad Ali Jinnah dies across the border. So you'll see on this day, all of that is taken account of. 942. So when I was preparing these submissions, I was very struck by that time. So given that time, you'll see the framers on page 1 start with remembering Bapu, noting that Muhammad Ali Jinnah dies across the border.
There is a speech by which Dr. Ambedkar presents the draft constitution to the
Yes.
Constitution.
And I have a picture of him in my office presenting the draft constitution to Dr. Rajendra Prasad. And it is the widest smile one could ever see from Dr. Ambedkar. So momentous times, my lords. I will just read this dual integrated judiciary, which is captured in the text of Articles 124, 217, 233, which we are debating 75 years since the Republic came to be. So what my lords are seized of today is a framer's intention, 25,000 sanctioned posts, and the heart of what the common citizen of India first interacts when she comes to court the subordinate judiciary. What the common citizen of this country faces is a police station and a subordinate judiciary. It is the heart of what is justice in the Republic. Now, please see, my lords, page 942. 3 paragraphs from the bottom, in the language of the framers. A dual judiciary, a duality of legal courts, my lords all have it, and a duality of civil services, as I said, are the logical consequences of a dual polity which is inherent in a federation. In the United States, the federal and state judiciary are separate and independent of each other. The Indian Federation, through a dual polity, has no dual judiciary at all. High courts and the Supreme Courts form one single integrated judiciary, having jurisdiction and providing remedies in all cases arising under constitutional law, civil law, or criminal law. This is done to eliminate all diversity in all remedial procedure. Canada, so on and so forth. Now, at the bottom, my lords, the dual polity, which is inherent in a federal system, as I said, is followed in all federations by a dual service. In all federations, there is a federal civil service and a state. My point is this, my lords. In this framework of the kind of a constitution that speaks to a unitary form with federal characteristics, the judiciary is intended to be an integrated judiciary. When we read 233, we must necessarily, to give expression to the framers, read 124 and 217 as a cohesive whole, harmoniously interpreting these textual provisions which constitute one single chapter known as the judiciary in the Constitution of India. That is the first submission. Now, 124, 217 and 233. Now, 124 and 217.
Why not 235?
Also, my lords, also 235. I bow down to my lord, the Chief Justice. Also. Now, my lords, if your lordship sees, and I'm not going to read it because my colleague, Mr. Shankar Narayan, read the provisions to your lord, to my lords before me. But when you see explanation 2 of 124.3 and explanation AA to 217.2, and this is all in my submissions, my lords, bar experience and judicial experience are treated as equivalent. It is the same stream, 2 rivers flowing into the ocean. I am asking that that constitutional ocean also be extended to 233, because that is the concept of an integrated judiciary. To do otherwise would not only impact the framers' vision of an integrated judiciary, but also the nature, the character of the Indian state, which unlike America has never been constituted or imagined to be federal, state, different. So if you, in the United States, every state has a state Supreme Court, which is magnum opus, my lords, in many areas. The federal Supreme Court only hears a select few cases. So that is not the conception here. So in this integrated judiciary, my respectful prayer number 1 would be, my lords, this is a composite judiciary. Please read these 3 articles of the Constitution harmoniously. And that is my first submission, my lords, in my written submissions. And a perfect example of this is when your lordships were seized with P. Ramakrishna Raju versus Union of India. This is 2014 12 SCC, page 20. And this is in volume 3, page 1203.
P. Ramakrishna Raju.
P. Ramakrishna Raju versus Union of India, 20.
1 minute.
Yes, my lords. I apologize, my lords. Volume 5.3, my lords. Judgments 1203, 1196, the judgment starts, my lords. Page 1196, volume 5.3. Paragraphs 19 and 20, my lords. I'll just read them to you.
1196.
Paragraphs 19 and 20. Yes. And the issue, my lords, is the purpose of drawing maximum pension. Could High Court judges appointed through the bar be allowed to count their 10 years of practice? A beautiful example. I'm sorry, my lords. My lord.
It's page 1196. The citation is 2014, volume 12, SCC.
Yes, my
And the
lords.
name of
Page
the-
1, my lord.
The name of the judge is N.V. Ramanna.
No, my lords, your lordship has 1196, my lord.
Yes.
P. Ramakrishna Raju versus Union of India.
Justice Sadasivan.
Yes, my lords.
Second Bogue and Ramana.
Yes, my lords.
Ramanna sir was a judge in 2014.
PDF 420.
It's okay.
It's volume Roman 5.3. No, my lord, Justice Sharma, this is it's a problem both ways. Both ways. Yesterday I was stuck in court just moving my iPad, pushing the papers along because it's difficult this way and difficult that way, my lords. It's a problem.
PDF 420. I got a hard copy.
My lord, Justice Sharma has the...
Trying to find it out. It's okay.
Grateful, grateful. So the issue here, my lords, is where for the purpose of drawing maximum pension, High Court judges appointed through the bar were actually allowed to count their 10 years of service. This was the question before my lords then. My lords, judgment written by Justice Satasivam. Now may I take you straight away to paragraph 19 and 20. My lords all have that. And this would be page 1203 of the compilation.
Para?
19, my lords. May I read, my lords? When persons who occupied the constitutional office of judge, High Court retire, there should not be any discrimination with regard to the fixation of their pension. Irrespective of the source from where judges are drawn, they must be paid the same pension just as they were paid same salary and allowances and perks as serving judges. Only practicing advocates who have gained eminence are invited to accept judgeship of the High Court. Because of the status of the court of the office of a High Court judge, the responsibilities and duties attached to the office, hardly any advocate of distinction declines the offer. Though it may be a great financial sacrifice to a successful lawyer to accept judgeship, it is the desire to serve the society and the high prestige attached to the office and respect the office commands that propel a successful lawyer to accept judgeship. The experience, my lords, the next page, the experience and knowledge gained by a successful lawyer at the bar can never be considered to be less important from any point of view vis-a-vis the experience gained by a judicial officer. If the service of a judicial officer is counted for fixation of pension, there can be no valid reason why the experience at the bar cannot be treated as equivalent for the same purpose. Fixation of higher pension to judges drawn from the subordinate judiciary who have served for a shorter time in contradiction to judges drawn from the bar who serve for a longer time with less pension is highly discriminatory and breach of Article 14 of the Constitution. Classification is unreasonable. So here, my lords, in fact, it's the flip. But the idea is the same. Two rivers coming to the ocean, treat both those journeys with equal respect, dignity, and therefore satisfy.
Both Allahabad and Yamuna and
My lord, my lord, my lord. My lords, my next point, my lords, and this is point 2, and I'll hand over this overview when I'm finished, my lords. My submissions are also there. Is by your lordship's judgment in All India Judges Association 2025, which has been dealt with multiple times, 3 years practice has become now mandatory, my lords, before one assumes the post. My Lord Justice Sundaresh Jr. also did this, my lords, and we heard the story yesterday, my lords. Following this 2025 judgment, my lords, the theory of separateness of the streams of legal experience no longer holds good. And this is a very simple but important point, my lords, that all candidates now will have a composite mix of experience in the judicial services and at the bar. So, Dheeraj More, which excludes judges from representation in 233(2), doesn't absorb the reality of what is judicial practice today in 2025, given my lord's judgment in All India Judges Association. And respectfully, my lords, any interpretation that restricts eligibility for direct recruitment to only those with exclusive and continuous bar experience only results in forcing those who enter judicial services to erase their own prior bar experience from professional records. It's a very simple point, my lords. I will not trouble my lords with the case. Now, my lords, the third idea is very simply this, that you cannot treat unequals equally. A flip part but important composition of Article 14. In this case, for instance, my lord, because I represent the client, he enters the judicial profession in 2011. He enters the bar at 2008. If he stands excluded, and this is an example, I'm not belaboring his case, this is just an example. If he stands excluded under 233(2), then he is treated the same as a fresher in the profession who clears the judicial services in the same batch, till All India Judges. So there will be these cases also, my lords, which applied before All India Judges.
How is the unequal being treated equally in this case?
My lords, there are two categories here, my lords. Here, because in everything prior to All India Judges, you had those members of the bench, the subordinate judiciary, who may have practiced for 3 years, 4 years, 5 years, as is the case with the client that I have, but then enters the subordinate judiciary. And at that time, when he took the exam in 2012, All India Judges 2025 was not the norm. So his experience at the bar is being excluded, my lords. That's the only submission, ma'am.
Statutory interpretation. Yeah.
Yes, but
Probably you can contend that any interpretation which might have a bearing on Article 14 can never be infused into understanding of the Constitution.
yes, my lords.
That
Yes.
is better.
And also, my lords, that the Constitution, as it is a living, growing document,
Organic document.
it's an organic Constitution. It has to be infused with the dynamism that it demands, my lords, and that this country demands. In fact, my lords, I was very struck, 1.3 billion people, 25,000 sanctioned judicial posts. We are surely one of the most underjudged countries in the world, my lords, because I actually went through the figures, and the figures, in fact, break it down by gender, by caste, by ability, and the numbers are very few. And for 4,000 vacancies, so 22% vacancies in this 25,000 sanctioned posts. We need to make these posts more attractive, my lords. One way of making them attractive is to make them equal access, but equal outcomes also.
Counter argument could be that if you permit this, then there will be many vacancies in the cadre of civil judge, junior division and senior division.
No, my lords, these sanctioned posts are civil judge, junior and civil.
Using of the subordinate judiciary.
Yes, subordinate judiciary, my lord.
You are arguing this. If you permit the civil judges, senior division and senior division, then all those posts would have fall vacant and the number of vacancies would further increase.
No, my lords, the civil judge junior division is 1,000 of these 25,000 posts, and civil judges 6,000.
That once you permit civil judges to take exam, many
Yes.
people
Will join the judiciary, and you won't have these 4,000 vacancies, my lords.
Recruitment process for filling of a civil judge junior division is comparatively easy than filling up the post of a district judge, where
Yes.
you require at most scrutiny here.
Yes, but my lords,
That's the reason why the Constitution consciously includes the Service Commission of the state
yes.
in consultation with the High Court there. Here
Yes.
it's a different ballgame there.
And my lords, the idea is to make that civil judge junior post attractive.
So to fill up the civil judge junior division, we could do it with the consummate ease. When it comes to the district judiciary, the higher judiciary, as in fact, which you are dealing with, it's a very, very difficult, laborious task. So,
My lords, if you see the recruitment exams in a place like Delhi, because this is very interesting, many young lawyers take those judicial services exams. Because Delhi is seen to be an attractive posting for a judge, there's good infrastructure, so on and so forth.
Delhi should not be the benchmark.
No, my lords, I'm only speaking of Delhi because for the first time, you have the numbers applying have changed. The numbers applying have changed. The composition of who applies has also changed, my Lord Justice Kumar.
Yes, anyway, we are no.
Yes,
Okay.
my lords, I will now bring myself back. My lords, the next point I want to make.
Your time.
No, no, my lords, nothing is a waste when I'm hearing from my
You
lords.
already exceeded your time because we have to hear all.
My lords, then I will finish in the next 2 minutes.
Yeah.
2 minutes. My lords, inter se cadre seniority amongst district judges, my lords. The last point I'd want to make, my lords, is simply this, that when we negate those years at the bar, then inter se between the judiciary and the district judges, there also becomes an unevenness. Because you have some who have pre the 2025 judgment entered with legal experience, advocacy experience, and some who don't. And then that seniority between them is also rendered fraught. My lords, the last point I want to make.
That's not an issue before us.
My lords, it's something that I have dealt with in my written submissions.
That issue is pending in All India.
Yes.
Case, but that's a different issue.
Yes, but my lords, this inter se seniority issue, I would request your lordship to consider.
That's not a question before us. Inter se seniority between the promotees and direct recruit.
My lords, it's also about how do we incentivize young people to take these exams.
Answer the question.
My lords, the answer to this question is that I am only trying.
We are here only to answer the question which are referred to us.
Yes.
We can't go beyond the reference.
No, this is as an issue which comes up today with the subordinate judiciary. That's my only point.
That's not an issue for consideration before us.
Very well, my lords. And lastly, my lords, I'll just say this, that we would want to facilitate and enhance access to justice and access to effective legal remedies. And one part of that is to ensure the best candidates are judges at the subordinate judiciary. Grateful, my lords. Grateful.
My lord, I am in 5011, item 1. This is a writ petition, my lord, where the candidate before your lordship, Dr. Mandeep Mittal, was granted permission to appear and has been 5011. Dr. Mandeep Mittal was allowed to appear, was working for the last 6 years as a additional district judge in Punjab. He has 4 years experience before that. I have nothing more to say. I have to adopt all the arguments. Everything is there, except Lord, one small addendum to what Ms. Guruswamy said. If your lordship has an opportunity to look at the entire system of promotion, appointments, etc., this extreme stagnation which is taking place in the judiciary from magistrates to additional is dissuading a lot of people from joining. There's an extreme stagnation from being a magistrate up to the additional district judge. So this is something that may take care of it. If they are allowed to participate, this is one measure that may take the interpretation. I'm not saying that this could be the reason for 233(2), but this can be a factor that can persuade your lordship. I have nothing more to say. Guys.
Thank you. Very, very precise and very brief.
Lord, I had just suggested to them that all those who just want to go in and out should have been given the opportunity in the morning. Who have not, because most of it has been said yesterday, actually. We are just repeating it and it's just wasting. I won't say wasting, Lord. Some of them will, I'll have a protest on my hands outside.
Yeah, all of you are enlightening us. That's all I can say.
To whatever extent we can.
Please, my lord. I appear for Avinash Kumar, my lord, who is a respondent number 2 in 501.15. His intervention was initially allowed, my lord, and therefore again he filed a IA 227875 of 2025, my lord. Now, my lord, he joined bar in 2006. He was appointed as a civil judge.
What number?
2 in, my lord. Now, my lord.
Point 15.
15, there is more. Now, my lord, he joined bar in 2006. On 23/4/18, he was appointed as civil judge. My lord, he was allowed to, he took a permission from the High Court and he was allowed to participate, my lord, in the higher judicial service. And thereafter, he cleared the written exams, but because of Dheeraj More, he was not allowed to participate in the Viva Voce. Now, my lord, Dheeraj More requires consideration on 4 counts, my lord, because of 4 reasons. 1, it compartmentalized 233(1) and 2. Second, my lord, that there is a negative stipulation which is provided. Third, the reading of phrase has been, my lord, as perfect continuous tense. And the fourth, my lord, that there is a quota for advocates. Now, my lord, may kindly have 233 once again, my lord. Give me the Constitution. My lord, 233, my lord, how it has been dealt with in Dheeraj More, my lord. Dheeraj More reads 233(1) as, my lord, appointment by way of posting and promotion. Now, what it provides, my lord, in para 12, it holds.
President said that appointments by.
My lord, may kindly Dheeraj More, my lord. Kindly Dheeraj More.
Appointments, postings and promotion.
And promotion. And promotion, my lord. And that's why it holds that one deals with promotion, posting and promotion, and two deals with direct recruitment from the bar. Now, my lord, may kindly have this reading of promotion. In fact, in the provision, it is, clause 1 says, appointment of persons to be and the posting and promotion of. Now, what Dheeraj More does is, my lord, it reads it as promotion to, which cannot be, because it presumes that insofar as the promotion is concerned of district judge, that would be taken care of in 2217. So this has to be to promotion 2, my lord, which was not the case when it was adopted. My lord, the Constitution the Assembly debates are very clear, and they were very conscious of this fact. My lord, the framers were very conscious of the fact that this would create confusion, and therefore, my lord, we kindly have the Constitution Assembly debates, my lord. This is CV volume 4, my lord, page 259. At 264.
Fine.
But 263, my lord.
Volume.
CV volume 4.
Yes.
4.1.
Yes, page number.
Page number 263.
2.1 short.
It begins from 776.
The one I had read yesterday was the history,
Where are the
which had all the previous, the government of
Which
India Act
volume?
1915.
Which volume, sir? 4A.
My lord, 263, my lord.
Yes.
Yes.
Now, my lord, 263, Pandit Hridayanath Kujuru. The object of my amendment Lord, got it?
Yes.
The object of my amendment is to allow high courts to be responsible for transfer and promotion of district judges in the same manner as they will be for the transfer and promotion of subordinate judges and other subordinate judicial officers. My amendment do not touch the question of appointment. The governor will appoint district judges in consultation with high court. All that I desire is that the district judges, after their appointment by governor, should be under the control of high court. I have, for my amendment, the authority is no less than a person that is chairman of the drafting committee, my honorable friend, Dr. Ambedkar. Now, my lord, it was inter se cadre, because, my lord, earlier, the district judges, had assistant district judges, my lord. It was the inter se promotion. And, my lord, if we historically look at the how 233(1) was adopted, my lord, the framers adopted broadly. framers adopted broadly the wordings of 254(1), my lord. And in fact, the control from governor was given to the High Court. So this anomaly, my lord, which exists and which is read repeatedly, is because the courts have read this promotion of as promotion to.
Amendment has been negative.
Yes.
But why? What was the reason, my lord? What was the backdrop?
Yeah, but then Dr. Ambedkar has.
But my lord, insofar as of is
Article 50 is very much there in the Constitution.
please, my lord.
We need to go to all this.
My lord, of
Article 50 specifically
Lord,
provides for separation of powers.
my respective submission is that of cannot be read as to. That's why, and my lord, may kindly have the historical background. Why it was provided? Because the powers which are vested in High Court by virtue of 233 are far wider power of adopting rules, framing rules for appointment of the district judges. In so far as, and therefore, my lord, Chandramohan, as it holds, that to provide for two sources. 233 provide for the sources, one provide for is a declaration giving
That's
power.
already been argued.
It has been argued, my lord. Now, my lord, kindly have my written submission, my lord. Just volume
You
one.
tell us rather than reading, you tell us what are your submissions, we will record them.
No, my lord, one thing no, my lord, if there is no bar, my lord, if there is no bar which is provided under the Constitution, it cannot be read in. Now, my lord, there is a bar which is being read in by Dheeraj Moore, my lord. Now, Manoj Narula, my lord, which is at volume 3, 778, paragraph 52, specifically provides, my lord, which holds that on a studied scrutiny of ratio of the aforesaid decision, we are of the convinced opinion that when there is no disqualification for a person against whom charges have been framed in respect of heinous or serious offences or offences related to corruption to contest the election by interpreting the provision, it is difficult to read the prohibition into Article 75(1) or for that matter into Article 164(1) to power of the Prime Minister or the Chief Minister in such a manner that would come within the criteria of eligibility and would amount to prescribing an eligibility, qualification and adding a disqualification which has not been stipulated in the Constitution. In the absence of any constitutional prohibition or statutory embargo, such disqualification, in our considered opinion, cannot be read into Article 75(1) of Article 164(1). Now, my lord, this honorable court, my lord, as the present reference is made under 145 of the Constitution of India.
Yes, thank you, Mr. Coach.
All right.
My lord, I beg to appear in item 501.18. Lord, most of the arguments, in fact, everything has been covered. I just wanted to show, my lord, how textually Article 233(2) appears if we look at the Dheeraj Moore judgment, my lord. I've just prepared a comparative table. Lord, may kindly see how the article appears. On the left-hand side is the original text of the article. And on the right-hand side, if we take the Dheeraj Moore interpretation, then what will be the, Lord, so what I have done, I have introduced the words as per the judgments in the bold and striked off the words which have been now read into. Lord, may kindly see the right hand side.
You are in which number?
501.18, Lord. Lord, he was a lawyer for 3 years. He qualified for the judicial services. He became a judicial magistrate, continued for 9 years as judicial magistrate. Then he got selected in the Delhi Higher Judicial Services exam. Lord, may kindly see. Yes, Director. Lord, now as per Dheeraj Moore, it reads like this. Only a person not already in service of the union or the state shall be eligible to be appointed a district judge through direct recruitment, provided he has been for not less than 7 years an advocate or a pleader is recommended by the High Court. Lord, clear violence to the text of the Constitution. 2. Lord, the Chandramohan interpreted word services as judicial services based on the text of Article 50. And now, my Lord, also post Keshwanand Bharti based on the basic structure, because there has to be separation. But here there is a complete new text which is read into 1, 2. My Lord, the Rameshwar Dayal and Chandramohan both says that the 233(2) provides for 2 streams. Now, because of this introduction of word only in the beginning, now only 1 stream is provided. Lord, I adopt the rest of the argument.
Thank you very much.
Deeply obliged.
Very brief and precise, like Mr. Valla.
Deeply.
Lords, I have been requested by the Maharashtra Judicial Officers Association to assist your lordships. I'll just take few minutes. We have submitted a formal application for intervention. Orders may be just passed if required. My Lord, I adopt the arguments on the interpretations of Article 233 that subclass 2 therein is only for the prescription of eligibility in respect of the advocates who are competing in the nomination process, appointment by nomination process. That is only the limited scope prescribing eligibility criteria, and that article cannot be read beyond anything there.
Providing a quota.
Provided. Quota is not provided there. Quota has come by way of judgments of your Lordship Court adopting Shetty Commission recommendation.
All India judges, 1.
1. And the 2002 judgment adopting the Shetty Commission recommendations of 25%.
But then the commission reports have not been properly considered even in that judgment.
I'm coming to that. My Lord, the origin of Article 233 is the 1935 Act, that is Section 254.
1915 and then 1935.
1935 Act, Government of India Act, 1935.
And then 1935.
1935 Act of Government of India, Section 254. And not the earlier rules. Earlier rules give some benefit of doubt to say that, look, there is sort of compartmentalization. That Mr. Bhushan has referred to the earlier rules of 1922 also. But the origin of 233 is in 254 of 1935 Act. But despite the 2 judgments, Constitution bench judgments of your Lordship's Court, that is Rameshwar Dayal and Saikia's case, the high courts on their administrative side all over the country believed that there are 2 different streams for appointment of district judges. One is by promotion, the other is by nomination. And so far as nomination is concerned, only advocates are entitled. This was the belief which prevailed till a judicial debate started in the case of Satyanarayana, which Mr. Singhvi just now cited before your lordships, that whether the judicial officer should be allowed to compete in the selection by nomination process. That was for the first time. And the Shetty Commission took note of this. And therefore, in its report, which Mr. Bhushan referred to, and it reflects in the judgment also of 2002, that Shetty Commission specifically recommended that the judicial officer should be allowed to participate in the process of appointment of district judges by nomination. Your Lordship's Court, for whatever reasons, remained silent, did not give any reasons.
Did not even say that.
Yes.
Though it is silent, but the first judgment also does not say that the in-service candidates would not be eligible for that.
It does not say.
So
It does-
it only-
Nowhere by judicial order, your lordship's court has said
It
that
only
they are not
specifies
entitled.
25, 25 and 50 quota.
Yes.
But doesn't restrict the judicial officers to courts.
No, it does not specifically, but the recommendation is not accepted. Now what happened, my lord, because of the judgment of 2002, all the high courts were directed to amend their service rules and fall in line with the judgment. As a result, now that quota of 50%, 25% and 25% came. Now, therefore, it is clear that if a judicial officer has to become a district judge, he is told that, look, there is a feeder cadre, namely civil judge senior division. Unless you are there, you are not eligible to compete as far as promotion process is concerned. Now, for the 25% quota, the high courts framed the rules and specifically barred the judicial officers. For example, I will place before your lordship, just for reference, Bombay High Court, Maharashtra Service Rules framed by the Bombay High Court.
That must be based upon the more.
Pardon me?
That must be based upon the.
No.
City
City Commission recommendation following that,
All India judicial officers want.
rules were directed to be framed.
Yes.
We take it. Because they also pointed out.
In Uttar Pradesh
Some
also.
other states also it is built.
Yes. Your lordship just sees Rule 7.
Karnataka has also said that he said, they have
Almost.
What is giving, you must give us.
Almost all the high courts updated their rules.
What is this?
Please come to page 5 of this. Page 4 is recruitment of district judges, Rule 4 and 5. And if your lordship comes to page 5, that 25%. See, 25% of the post shall be filled by nomination from amongst the eligible person practicing as advocates on the basis of a written and viva voce test conducted by the High Court. Now, on the right-hand side column, what my lord the Chief Justice said yesterday, experience must be practicing as an advocate in the High Court or court subordinate thereto for not less than 7 years on the date of publication of the advertisement, and while computing the period of practicing as an advocate, the period during which he has held the post of public prosecutor or government advocate or judicial officer shall be included, or must be working or must have worked as a public prosecutor or government advocate for not less than 7 years in the post or post on the date of publication of the advertisement, and while computing the period of service, the period during which the candidate has practiced as an advocate shall be included. So there was a specific indirectly bar for any judicial officer to compete in the process of appointment by nomination.
No, but must be practicing as an advocate in the High Court or court subordinate thereto for not less than 7 years on the date of publication
Yes.
of that bill. And while computing, so
Yes.
this bold,
Judicial officer is not there.
but why it is there? Or shall be included, it is there, included.
While computing the period of practicing as advocate for
So this is a bold you want to introduce or it is already there?
Remember, my lord, when he was a member, but for suppose 2-3 years, he had worked as a judge and then resumed practice. In those cases, this applies. Suppose there was a candidate who joined the judiciary, resigned, and then. Yes, that period also has to be counted. That is something like.
So that can be counted. So suppose if he resigns,
Yes, this is counted.
it is counted.
Yes, but sitting judge, no. That is what
He
happened.
did not go into the rules of which he.
I am just giving the historical.
No, that's a great,
This is-
that's
this-
why you are
this is
here.
What happened? This is what happened.
That is the reason why you are here now.
Therefore, my lord, there is no specific bar in the constitution, but
Constitution of वही 2010 में है.
अच्छा, okay. I'm sorry.
Now whether the High Court has amended in accordance with Dheeraj Moore.
not yet.
It has not been amended so far.
My lord,
It has not been amended so far.
so far, to my knowledge, no. I do
That's
not
not
know,
possible.
because I read the High Court's affidavit also. Bombay High Court has filed an affidavit.
It's a
They do not refer to the, but they refer to the judgment of Moore and say that whatever has been held there is correct law and the judicial officers should not be allowed to
This
compete.
is contrary to the stand they had taken before the Shetty Commission. The Bombay High Court in the
Yes.
Shetty Commission submitted that the judicial officers should be permitted to compete
Yes.
against that
Yes.
quota. That will enhance the quality
Yes.
of the judicial administration and all that.
Allahabad also, Bombay also.
Bombay also.
And as a matter of fact, Shetty Commission has appreciated the stand taken by the Bombay High Court.
But Bombay High Court has filed an affidavit and I said that
You know,
whatever is decided by.
Obviously, for the reason.
you know how these
Just
affidavits
for
are
us
filed.
come. See, as a High Court, you're supposed to follow the Supreme Court. The right or wrong is indifferent.
Yes,
different
yes,
issue.
yes. We know how the affidavits are filed. That is for a larger debate. So let us not get into that. So I adopt the arguments and say that, look, there is no prohibition.
Thank you.
And it has to be read as it is. And the judicial officers are entitled. My lord, I may also say that any judicial.
That's correct. That's what this is the point in that. Yes.
Just one line. Any judicial officer, whether he is in junior division or senior division.
That goes without saying. Nobody is saying. It's not a promotion.
Yes. I don't wish to take your lordship.
Thank you.
Thank you.
Yes, Mr.
Please, Lordships. Lord, I am appearing in this IA, which is listed at serial number 5 in the today's office report. Lord, my case is that I appear for Dr. Karuna Sharma, who was enrolled as a lawyer in 2005. Then, my lord, she joins as a judicial magistrate in December 2013. Then, my lord, because I had more than 7 years of practice as a lawyer when I joined service. Then, my lord, in 2015, Punjab and Haryana High Court advertises 6 posts of additional district and session judge. Because, my lord, the Punjab and Haryana High Court did not debar it. Anyhow, after this advertisement dated 16th of July 15, Vijay Mishra judgment came on 9th of August 2016, which said if you are, you have requisite experience of 7 years as a lawyer, then 233 will not debar you from becoming eligible, because the ratio says that you can, selection is different from appointment. 233 doesn't debar you from applying and participating in the selection process. When it comes to appointment, you can always seek an resign and seek an appointment. So, my lord, the governing law of the land as on 17th of August 2016 was Vijay Mishra. Punjab and Haryana High Court issues a corrigendum in line with Vijay Mishra. So, my lord, I, as eligible candidate, applies for appointment. Out of the 6 posts, my lord, I became the topper. And, my lord, ultimately, because, my lord, this selection process and the corrigendum by Punjab and Haryana High Court in line with Vijay Mishra, one writ petition came to be filed challenging the corrigendum by the High Court in line with Vijay Mishra. And that writ petition was, my lord, in 2017 by one Anmol Nair. Writ petition was dismissed by saying that the corrigendum is in line with the law laid down by Honorable Apex Court at that point of time. I came to be appointed as ADJ, my lord, on December 2018. In the meantime, this Anmol Nair had come to this Honorable Court. No stay was granted. SLP remained pending because simultaneously Dheeraj Moore was also pending. Ultimately, my lord, Dheeraj Moore says Vijay Mishra is a bad law. And now, my lord, I want to invite my lord's kind attention to the concluding para of Dheeraj Moore, how this Honorable Court has dealt with the cases where the appointments happened pursuant to the interim orders passed by this Honorable Court. Lord, may kindly permit me to go to para 47 of Dheeraj Moore. Lord, this is volume 3, page 1005. Just, Lord, it is in the CB compilation, my lord, page 110 is relevant para, my lord, I want to.
Paragraph you want to refer to?
Para 47 and 48. Lord, just the Roman 6 of para 47. My lord, has it?
Yes.
Para 47, Roman 6.
There is no Roman 6.
It's 6. This is, my lord, para 0.6, my lord, 0.6. In my case, it's shown Roman. The decision in Vijay Mishra, my lord, God.
Yes.
The decision in Vijay Kumar Mishra providing eligibility of judicial officers to compete as against the post of district judge by way of direct recruitment cannot be said to be laying down the correct law correctly. Same is overruled. Now, my lord, may kindly see the next para is important. How these appointments have been dealt with. In the case of Dheeraj More and other cases, time to time interim orders have been passed by this court, and incumbents in judicial service were permitted to appear in the examination. Though later on this court vacated the said interim orders, by that time certain appointments had been made in some of the states, and in some of the states results have been withheld by the High Court owing to the complications which have arisen due to participation of ineligible in-service candidates as against the post reserved for the practicing advocates. In cases where such in-service incumbents have been appointed by way of direct recruitment from the bar, as we find no merit in the petition, and due to dismissal of the writ petitions filed by the judicial officers, as a sequel, no fruit can be ripened on the basis of selection without eligibility. They cannot continue as district judges. They have to be reverted to their original post. In case they are right in general, that's not relevant. The point I'm making is this. My lord, in para 48, this honorable court in Dheeraj More says, because you participated in the selection process pursuant to the interim orders we have passed in here. In some cases, interim order continued. You, because of the interim order, you participated in the selection process. You might have been even appointed. And in some cases, the interim orders were vacated. And hence, because ultimately the writ petitions are being dismissed, so you cannot, the benefit you got pursuant to the interim orders cannot inure to your benefit. My lord, the category of cases probably were not brought to the notice of this honorable court, like the one I am representing.
We are not deciding in which way.
My lord, what I am submitting is Dheeraj More need to be clarified. My lord, if assuming, my lord, assuming against myself that Dheeraj More is upheld by this honorable court, still, my lord, the people who got appointed.
That is not that is for that the independent petitions will be decided by the benches.
My lord, because my lord, it is in view of Dheeraj More. They have reverted me subsequently in 2020, saying that Dheeraj More has decided. Now you have to be reverted. My lord, I was appointed when Vijay Mishra was governing the field.
We are not deciding an individual petition.
That's
whatever we lay down herein, the concerned benches will decide on the basis of the law laid down.
Only, Lord, just two respectful submission. One is, Lord, may consider clarifying it that the people who were appointed.
That's not a question before us. We have framed particular questions.
I bow down.
They will be answered, and whatever is answered, the benches will decide the independence in accordance with the answer.
So, Lord, that's clarified. Just one thing otherwise on merit, Lord. While interpreting 233, Lord, Vijay Mishra, in my humble submission, judgment is consistent with the Article 14 and 16 of the Constitution of India. Because, my lord, merely because, my lord, this is an appointment for the post of district judge. And I may be ineligible to apply because I do not have a 7 years experience as a lawyer, which is prescribed. But if I am eligible as a lawyer prior to joining the service as a judge, I becoming disqualified only on account of the fact that I am already a judge.
That has already been argued by.
That's right. That's right. So, my lord, this is all.
Thank you. Thank you. Yes, Mr. Murali.
May I please, Lordships. I'm in 501.3, your Lordships, and RP number 381 of 21. My written submissions are in volume 1, page 55. In fact, the petitioner number 1 became an advocate in 2000. He got appointed in 2014.
Yeah, serial number?
Serial number 501.3, your Lordships.
501.3.
My written submissions are in volume 1, say at page 55, your Lordships. I primarily represent 3 judicial officers, your Lordships. Petitioner number 2 got enrolled as an advocate in 2000. He got selected to the as a civil judge in 2014. As on the date of his appointment. In fact, he had completed 13 years, 5 months, Your Lordships. As regards petitioner number 2 is concerned, he got enrolled as an advocate in 2002. He got appointed as a civil judge in 2014. He had about 11 years experience. And as regards petition number 3 is concerned, she got enrolled in 2005 and got appointed as a
We
civil
are not
judge.
going on to the individual facts.
Please, Your Lordships. Primarily, all the three of them.
Consistently that the individual matters will be decided after the reference is answered.
Please, Your Lordships. Primarily, in fact, all the three had, let's say, more than 7 years, more than 10 years plus of experience.
Not going into facts.
Anyways, there's not much to argue because it's all been covered, Your Lordships. In fact, I had only one point that is there as regards prospective overruling, Your Lordships. In fact, my Lordships may have, let's say, the written submissions that's there.
Paragraph 10.
Please, Your Lordships.
10.
Paragraph 10, Your Lordships. Even presuming for a moment, in fact, let's say if your Lordships were to actually hold that Dheeraj More holds the field also. As on date, okay, Vijay Mishra was the law in 2018 when I made my applications, where in fact I cleared my vivos, I cleared, let's say, my prelims, mains, and vivo C. Now it's only primarily, let's say, the order, let's say, the interim order, let's say, in Dheeraj More in 2018 for the first time when I used to be appointed. In fact, let's say, appointments would be given. In fact, it actually said that you will not be entitled to. In fact, what my learned friend actually read in paragraph number 48.
Not going into individual cases, they will be decided on their own merit.
Yes.
Please, Lordship. In fact, okay, there's one judgment wherein, say, I had a legitimate expectation. Now, in fact, please, Lordship, I rest my case. In fact, otherwise, let's say, I believe it's all covered.
We appear in item 50.19. Lord, I appear in item 50.
Lordship, I have to bring in your notice the injustice created by the nodal counsel. Nodal counsel is not allowed to decide whether the advocated record would not argue in this court if the senior counsel is not engaged. He is taking the space of this court. I have filed my written submission timely, but he intends.
What do you want to argue? Tell us, what do you want to argue?
Lord, I appear in,
Let him argue.
Lord, I am appearing in item.
Let him argue, so he's so anxious.
Quick, Mr.
He's so anxious, so let him argue.
He has to be there in every constitution.
Lordship, I am appearing for the item number
Lordship,
501.
his written submissions, page 113. No, that's something seriousness has to be there. Page 113 of the compilation 1 is the written submissions of Dr.
Yeah, absolutely.
Lordship, can you see that?
Lordship, can I start?
Then your submissions are good enough. We'll look into it. It says the cases should be decided
according to the constitution and law.
Because Lordship, at the last point we have to.
I'm not finished. We'll do that only. Matter ends.
Lordship, can I say one thing?
Your prayer is please decide the matter as per the constitutional provisions. I'm assuring you again and again we'll do that.
Lordship, we have to explain what is left at the last. So that's why we have.
After so many years of practice, I mean, you mean to say we don't follow the Constitution of India?
Yes, all those who want to say something, they can give.
Lordship, I will explain totally new points if you allow me.
Thank you.
Lord,
We have seen your submissions, we will decide according to your submissions.
Lord, I appear in item 501.19. Mr. Shoaib Alam, senior advocate, had to argue this matter, my lord, but I'm sorry he is not available. With some difficulty, my lord. That's why may I just make a small point? It will not take much more than a minute.
Yes, what do you want to ask?
Yes, my point is this, that as far as Article 233 is concerned, it starts with appointment of persons to be. The first part deals mainly with the judicial officers. And as far as the second part is concerned, it starts with a person who is not in the service of the union or state. So first part deals with the judicial officer. The second part deals with somebody who is not in the service of the union or who is not a judicial officer. For them, the qualification prescribed.
That we already argued, yes.
Yes, my lord. As far as the facts of my.
Facts we are not deciding, yes.
My lord, I have already completed 7 years of practice before joining the Bihar subordinate judicial service. Thereafter, the advertisement came, and as per the advertisement, I had.
We are not deciding the individual cases.
So I'm just on a small point. And that point was.
Mr. Shan, please don't embarrass the court like this.
I'm so.
By arguing contrary to the constitutional bench judgment.
I'm so.
Thank you.
Lordship permission, my lord, I am appearing in 501.8 of the Kerala batch of cases. What is left out, Ms. Naidu has argued about that. I am representing those judicial officers, those who are in them. My lord, one small submission in this.
You don't permit more than one person to argue in the
One small submission. That's in my, because post Chandramohan, my lord, there is a constitutional amendment which has been taken place, 233A. There is also the rule of 7 years has been categorically specified in that. This has not brought to your notice, my lord. So I just wanted to mention that aspect. Second aspect is, my lord, in Chandra Mohan, the definition given to the service is also incorrect because 236 very categorically, 236B, my lord, defines the judicial service. So the definition which has been extended to exclude the judicial magistrates is incorrect in my opinion. To that extent, my lordship has to distinguish Chandra Mohan. Rest all the submissions, my lord, I am adopting.
So we want to refer to larger bench.
No, my lord, I'm not saying that it need to be. I'm not saying that, my lord, because that situation demanded that.
We are quite conscious of it. That is the reason why Senegal's also they are not gone into that.
And Lord,
therefore we are proceeding on the footing.
233 amendment.
We understand difference between 233 and 234. 235 on one hand, you want to say they won't say judicial service, others say mainly service. Got it? You understand?
That's one thing, and 33A, the amendment 7-year rule has been reiterated.
Don't cause more damage to your own client. Thank you.
Deeply. My clients are all having 7.
My lord, I am appearing 0.23, my lord. I am sorry I did not get chance to be included in that list, my lord. I have prepared a written submission, my lord. I want to.
What do you want to say? You tell us.
Yes, my lord, just 2 things, my lord, apart from submitting these.
Forget about what. Tell us what you want to say.
My lord, first thing, my lord, this advocate quota is not by way of affirmative action, my lord. This was not embedded in the constitution, my lord.
Yes.
If this is read as contradistinction to the service quota, my lord, this will be read as open quota, my lord. And if it is read as open quota, everyone will be included, my lord. And this will cast the net wider, my lord. Why I am saying that, my lord? Even in Bar Council rules of 1975.
Constitution.
Just one part, my lord. That part-time teaching,
etc. What is right, what is wrong. We are not even. The Honorable Chief has already said a number of times. We are not deciding yet. It's not a rule or act.
Just on the principles, my lord. Just to cast net wider, my lord, so that merit is.
That is already been.
My lord, we have included some quotes from ancient text, my lord. This
Not,
we have
not
in writing judgment.
Not disputed.
My lord, I am appearing in 5014. The only fact which I would like to bring to notice of my lord is that I was competing with the SC quota, my lord, and prior to.
We are not going into the individual matters. How many times we have to tell you the same thing?
My lord, this may be taken.
No,
my lord.
Lordship, I have to reply the Hansaria sir objection
thank
because I was stopped from the argument after his objection. Only 1 minute I will satisfy.
Thank you, Mr.
He,
Sharma.
Lordship, I am not arguing about the matter. I am just very important thing. There is the difference between the written submissions and the argument. Argument includes the logic and the explanation by the advocate and the questions from the bench also, while the written submission only outlines the basic framework in which we have to argue. And there's the question on my written submission. Lordship, in my written submission, 3 parts. In first, I mentioned the issues. On second, I wrote, they should be responded according to constitutional provisions and law. That means I will speak only on that specific provision which is mentioned in the issues. And third,
Mr. Sharma,
it is because argument.
we are called upon Mr. Singh.
Pardon, Lordship?
We are called upon Mr. Singh to argue. Yes, proceed with it.
Lordship, Hansaria sir objected, so that's why I have to reply. He raised the objection. So,
Don't force us to make anything unpleasant.
Lordship, I always,
Don't force us to take any unpleasant step.
Lordship, I am grateful,
Yes.
but I have to reply so
Don't-
that objection, so that.
I'm repeating it for the 3rd time. I won't repeat it on the 4th time.
Lordship.
May it please, Lordship. This I appear for in serial number 501 for the respondent, who is the member of the bar in Kerala, who has been selected, she was one, Mr. Rajneesh, who is the petitioner in 501, they're both in a reserved category of other backward classes. He was at number 2 and I was at number 4. In between were open candidates 1 and 3.
You're from the reserve category.
Of other backward, there's a particular community reserved for that. So he was within our snubs, he was number 2 on the select list. I was number 4. 1 and 3 were open general candidates. So between us, he's one position above me. He's a serving member. He was a munsif serving.